Economic Development Analyst at the City of Evanston in the Housing and Grants Division of Community Development. And we're here tonight for a webinar geared towards landlords to talk about the different resources that are available for landlords in the City of Evanston, and also some best practices for Evanston property managers and owners. And joining us today is the Metropolitan Tenants Association and also the Lawyers Committee for Better Housing. So I just want to get a little bit of housekeeping items out of the way. At the end of this webinar, we will have a 15-minute question and answer session. So if you could please leave your questions in the question and answer box, that would be great. If you would like to speak during that time, we'll let you know when the question and answers start, and you may raise your hand and I will go ahead and call on you to speak. But we will reserve questions until the question and answer portion. Also, at the end of this webinar, once you close out and leave the meeting, you will be prompted to give your email address. And this is if you'd like to receive a recording or a link to the recording of this webinar, and also the links that you will be seeing on the screen. So I'll go ahead and get started and present our wonderful organizations that are joining us today. So we have Taff West representing the Lawyers Committee for Better Housing. He is the Vice President in Technical Assistance and Sustainability for Chicago Community Loan Fund. Taff began his real estate career in the late 1970s as an assistant manager trainee at a high-rise market rate development with over 2,000 apartments and 30 commercial units near Lake Michigan. During his 30-year real estate development career, Taff worked in various management assignments, including condominiums, affordable housing, and public housing. Taff began taking his peers to visit schools in disadvantaged areas for career days to share the students how life experiences lead to various careers. In 1997, Taff returned as a general manager to the 2,000 unit lakefront high-rise where he began his career in the 1970s. This property had suffered 6 years of budget deficits of $3 million, plus annually amount, and average vacancies of 200 units. After 1.5 years, the deficit was erased and the property enjoyed a positive cash flow of $1.8 million. With an assist from customer service training, morale was again very high. After this property regained its stature, the firm was named the best in the industry. During 2001, Taff received his broker's license and began working with Community Investment Corporation as a contract trainer in the property management training program. He taught preventive and routine maintenance systems to property management students. In 2002, Taff joined CIC as the deputy director of this program. And after a hiatus of several years of consulting work, he was named director of property management training in 2007. The Chicago chapter of Institute of Real Estate Management awarded Taff with its annual Premier Education Award in 2009 for outstanding commitment to enhancing the education of the property management industry. In 2013, the Metropolitan Tenants Organization of Chicago awarded Taff its Tenant Champion Award in recognition of his support and commitment to Chicago's tenants by teaching landlords to be great stewards. The Association of Illinois Real Estate Educators recognized Taff as the 2013 Educator of the Year in recognition for his outstanding dedication to the real estate education. Only one real estate educator per year in Illinois is honored with this designation, and Taft attended the University of Illinois and Roosevelt Universities. Taft joined Chicago Community Loan Fund in April of 2017 as Vice President of Technical Assistance and Sustainability. He manages all aspects of technical assistance, sustainability, and good design programs. He is also a United States Army veteran, and he served as a medical corpsman during the 1962 through 1965 Vietnam era war. So welcome, Mr. Taft. Thank you for joining us today.
Thank you. Gosh.
And we also have here today, once we have here Phil Devon from the Metropolitan Tenants Organization. And 1 second, I will get his bio ready. I'm having some technical difficulties.
Well, I'm happy to introduce myself if you'd like.
Sure, that would be great.
Hi, guys. Philip Devon from the Metropolitan Tenants Organization. I've worked with MTO and doing housing work for the past 9 years. I'm also a licensed attorney that does some civil rights and fair housing work outside of my work with MTO. Primarily at MTO, I manage our eviction prevention program, which really seeks to intervene and help landlords and tenants stabilize their housing and avoid eviction court, avoid displacement, and avoid folks having to move without at least the dignity and time that they deserve. And so our program really helps put into practice, I think, something I probably learned from Mr. Taft West, which is, one of the best preventative measures for housing issues are good landlord and tenant relationships, and ways to solve existing problems is usually with good communication. And I think that's something our program at MTO does well and is very useful, because what often landlords need is real world practical tips and information, not just regurgitation of what the rules are. So that's what I'm happy to do. We work in partnership with the City of Evanston, answering questions for landlords and for tenants, and work closely with the Lawyers Committee for Better Housing, which Taft is not with LCBH, but as a good segue, we do have John Raffensperger, who is here today and is with Lawyers Committee for Better Housing. And maybe I'll pass it over to John to introduce himself.
Thanks, Phil. Hi, I'm John Raffensperger. I'm a senior supervising attorney with Lawyers Committee for Better Housing. I've been with them for about 6 years at this point. Before that, I was in private practice, with Winston and Strawn, and then with Butler, Rubin, Saltarelli, and Boyd. With LCBH, I work on eviction cases, on cases involving a variety of different landlord and tenant situations, conditions, problems, various kinds of unlawful conduct. And so I have a broad experience with landlord tenant issues, particularly in Chicago, but we also work with tenants in Evanston and in other Cook County suburbs through the early resolution program in eviction court. So I'm pleased to be invited to be here today, and look forward to sharing with you some information about being a landlord in Evanston. And then I think, Phil, are you kicking us off today?
Yeah, I think so. And so I think we can go to the next slide, which, as you can see, we're here in current resources for landlords. That's me. John will be talking next just about some relevant laws and things to be aware of as property owners or property managers. And then Taft will be following that up with some general tips and best practices for property owners and managers. And as evident from his bio, he has vast experience with that and is a great resource to have. So I encourage everyone, as Anna said, to put any questions that you have in the Q&A, and we'll definitely address those at the end of the presentation. I already saw one question in there. We'll certainly answer that and hopefully some more. At MTO, as I mentioned before, and I know my camera is off. I don't know if anyone, I don't think I have permission to turn it on, but I'm happy to have it on. At MTO, our eviction prevention program really does one thing well, which is stay in the know about available resources and up-to-date kind of resources that are available to both property managers and landlords. And one thing that I think is very helpful for a lot of the landlords I talk to is learning about available resources for tenants that they didn't know about. I've helped several landlords get assistance for tenants that weren't paying rent and help those landlords, of course, avoid the cost, headache, time, and you know, all the other things that come along with having to take someone to court over something like rent. So MTO is a great resource. If our information is not already in the slides, and I don't know if our number is, but I'd encourage any landlord in Evanston, because I work closely with the city, to contact me if you have questions or follow up. You can call 773-292-4980, and my direct extension is 246. I'm happy to answer any questions and, of course, connect you with any resources, whether that be legal, rental, or otherwise that I can. So with that said, we can move on to the next slide, and I'm just going to outline a few relevant resources and things that I think everyone should be aware of. The first of which is, if you're a property owner in Evanston, you have to register your rental property. You don't want to get dinged with a fine or run into other issues, so make sure that you're doing that. If you are a first-time renter, or rather a property owner that is renting your unit, you have to pay a $200 new registration fee. And you'll see this on the screen. That is the one-page form that you need to fill out and send in. You can mail it in. You can also do this all online. That link on the bottom left of your screen, Evanston registry link, is a direct link to do so online. And then yearly renew and just make sure your information is correct. The renewal fees are much less. I think for most folks that own between like a 2 and 4 unit building is a $30 annual fee, and I think $50 for 5 and 12 units, slightly more the more units you have, but not the $200 initial fee. A couple reminders about your registration, what comes along that, which I know no one likes inspections, but that does is going to result in inspections. And for the past couple of years, due to COVID, most of the inspectors with the city have focused on complaint-based issues only, but the scheduling of routine inspections has resumed. So scheduling will be coordinated directly with you, not your tenant. Just be aware of that. And expect, contact from the city if you haven't already been contacted, and that will be going forward. We can go to the next slide. Thank you so much. Again, if you're watching or listening now, no need to be like, oh my gosh, I have to write all this down. If you just put in your email at the end, you'll be emailed all of these links, which are very helpful. The first is just, again, another link to register the property, make it super simple. It will take 5 minutes or less. You also a link to pay the fee, and then a couple other helpful links in here. The property standard search tool on the which is provided through the city will help you see if there's any violations at your address. Anyone can look at this, but it's always helpful to make sure you're on top of things and see if something is there that you're not aware of. You can take care of it. The next two are also very helpful, because once the city starts doing these routine inspections again, you're going to want to make sure that you're prepared. Hopefully you're prepared at any time and you don't need to prepare because you've already got everything in order. Everything's up to the best it could be. But that's not always the case. We all know this, and things happen. So use this property standards pre-inspection guide. It'll basically a checklist, and then you can do a self-inspection. Both of those links are there. The self-inspection is helpful just for your records. or, before a move in, after a move out, these types of things. Because documenting conditions is the best way to avoid a he said, she said, which I run into a lot. And I often ask both landlords and tenants, well, did you take a picture or did you write it down? And way too often the answer to both of those questions is no. You always want to document everything. It's going to help everyone in the long run. There's also a link here for renters, resources for renters. So if you have a renter that is struggling or has made you aware that they might need assistance or other support, you can send this link to them and they can be connected with MTO or other folks that can answer their questions and give them some assistance. Lastly, just a few key documents I've linked. I think John will be going into these in much more detail here in a moment, but that's the Evanston RLTO, the Evanston Fair Housing Ordinance, and just a model lease agreement that you can use to create a lease with a new tenant. Again, link on the bottom right in that square, get your property registered if it isn't already. And then lastly, on the top right, the city needs your input right now because the Small Landlord Task Force is actually designing a landlord assistance program, and they're trying to get input from landlords. So if you haven't already, please go to the link in this slide and complete the survey because the program is being designed for you. So you want to make sure you have your input and that it's actually going to help you when it is actually rolled out. So important, get the word out and make sure anyone else that owns property or rents in Evanston also fills out that survey, and then share all this information with them as well. With that, I think that was everything that I'm going to cover at the moment, but I'm going to be around for Q&A as well. And with that said, I'm going to pass it over to John with the Lawyers Committee for Better Housing, and he's going to give you a bit of a review and just overview of relevant laws to know as a landlord in the city of Evanston.
Thanks, Phil. And just to get started, I mean, relevant laws is an incredibly broad topic. There are a lot of laws that touch on the landlord-tenant relationship. Because we don't have a lot of time tonight, I'm going to focus on the Evanston Landlord-Tenant Ordinance because that's the law that's most often and most directly relevant to landlords and tenants in Evanston. At the end of my section, I have a slide with some other laws that are relevant in certain situations. We'll just take a really quick, just broad 30,000 foot view of what those laws touch on, but we're not going to have time to cover them in depth today. You move to the next slide, please. So this is basically what I'm saying here is that there are a ton of laws. If in doubt, if you're not sure about a situation, reach out to MTO. That would be a good resource to start. We work with them closely, and if there's a legal issue that they're not sure about, they ask us. We work most directly with tenants, but I will also sometimes advise landlords if they have a legal question. And then there are other legal resources, private attorneys and things like that that can be helpful as well. So if in doubt, ask. Next slide, please. So to start out, just in general, Evanston has its own landlord-tenant ordinance that's different from the Cook County ordinance or the Chicago ordinance. And so if your property is in Evanston, this is the ordinance to be looking at. It's found in the Evanston Municipal Code, Title 5, Chapter 3. I've included a link here. Like I said, we're going to focus on this today because it answers most questions about rights and responsibilities of Evanston landlords and tenants. But you should remember that just because you don't see something in the Evanston ordinance, that doesn't necessarily mean there's no law about it. That just means that the Evanston law doesn't cover it. Next. So who has to follow the landlord-tenant ordinance in Evanston? And the answer is almost everybody. It applies to almost all people who would be considered residential landlords, regardless of how small the building is or whether the landlord lives in the building or not. And that is different than the Cook County ordinance and the Chicago ordinance, which have kind of broad exceptions for what people refer to as small landlords who live in the property and it's only a small number of units. The only exclusions from the Evanston ordinance are for certain living situations that are not really what you'd think of as landlord-tenant, medical facilities, nursing homes, colleges, hotels and motels, things of that nature. Who does it apply to? Almost everybody who's a landlord. Next. We can start at what is generally the beginning of the landlord-tenant relationship, leases. In Evanston, to comply with the ordinance, you have to have a lease. The city has a model lease that landlords can use, and I've included a link to that here. Phil mentioned that as well, I think. Or landlords can use their own lease as long as it complies with the requirements of the ordinance. If the landlord doesn't provide a written lease, it's important to note that that doesn't mean there's not a tenancy. That just means that this tenancy is going to be the landlord's going to be in violation of the ordinance, and they've established a verbal tenancy under the law of Illinois. So if not having a written lease doesn't mean there's not a tenancy. It just means that the landlord needs to have a written lease to comply with the ordinance. The lease doesn't have to be signed by everybody in order to be effective. If the tenant pays rent and the landlord accepts rent and one of those parties hasn't signed the lease, well, guess what? The lease is in effect. It's deemed to be in effect under those terms. The lease can't require tenants to waive their rights under the ordinance. So even if a landlord writes a lease that says, the tenant says something different or contrary to the ordinance is going to control. So it's better to just have the lease correspond to the ordinance, which is why the model lease is so helpful. A couple things the lease has to attach, a copy of the landlord-tenant ordinance. I've included a link for that here. I think Phil also has a link to the ordinance summary. And there's also a lead pamphlet to give tenants information about possible lead in older properties. That also has to be attached. It updated from time to time, so I've included a link to where that can be found. Next. So other thing that has to happen at the beginning of the tenancy is the appropriate disclosures, things you have to tell the tenant about the property. And about the landlord. So before the start of the tenancy, the landlord has to disclose in writing the name, address, and a 24-hour phone number for the property manager, whoever is going to be managing the property. Sometimes that can be the landlord themselves. Sometimes that can be, a professional property manager or some other individual. They also have to provide the name and address of the owner or the person who's an agent of the owner for purposes of receiving notices and things like that, so that the tenant can send appropriate notices to the owner when they need to, or serve them in case that things go sideways and you have to have a lawsuit. This information has to be kept current, and so if any of that changes, you got to let the tenant know. The landlord also has to disclose in writing any code violations that have been cited by the city. So if the property is inspected and the inspector finds something wrong, you got to tell the tenant about that. And finally, any known lead hazards. If you know that there is lead paint in the property or lead in the soil, things like that, that also has to be disclosed at the beginning of the tenancy. And that's just so that the tenant knows what they're walking into. If there's some kind of conditions issue with the property, it's better that they know up front and they can decide, okay, do I want to live here or not while it's being repaired, rather than being surprised upon moving in and it leading to a breakdown in the relationship and legal consequences. Next, please. So another thing early in the tenancy that a lot of landlords have to consider is whether they're going to take a security deposit or whether they're going to ask for prepaid rent from tenants. We'll talk about just now, that can get a little complicated in terms of what needs to be done with that. So the ordinance requires that if the landlord does decide to accept a security deposit or take prepaid rent from the tenant, it can't exceed 1.5 times the monthly rent. So that's the most that the deposit can be. If it's more than 1 month, the tenant doesn't have to pay it. If it's more than 1 month's rent, the amount, the tenant doesn't have to pay that all at once. They can instead choose to pay the portion that's in excess of 1 month's rent in installments, and they could have up to 6 months to pay those installments. The deposit or prepaid rent has to be held in a bank account. It has to be held in a federally insured interest-bearing account that's separate from the landlord's money. If the landlord puts the money in their own account, that's called commingling, and that would be a violation of the of the law. So the landlord has to have a separate account to hold security deposits or prepaid rent in. And the landlord also then has to pay interest. And that shouldn't be too hard if it's being kept in a separate account, because usually it's keyed to, what the interest rates are in savings accounts and things of that nature. But you got to check. So if you're keeping prepaid rent or a security deposit, rent has to be paid annually in cash or by a rent credit. So, likely this is only going to be a few cents. So you just take it off of the month's rent payment or something like that. But it has to be done, or else you might be in violation and subject to damages. What the interest rate is determined every year by a formula by the City of Chicago, and that's what the Evanston Ordinance is keyed off of. So I've included a link to that page here so that you can check what the interest rate should be on the deposit. And then at the end of the tenancy, the amount of the security deposit can be applied to any rent that the tenant owes or any damages that they have caused beyond normal wear and tear to the property. But in order to make those deductions, the landlord has to send the tenant a written notice within 21 days after the tenant vacates, telling them what it's being applied to. So what are what's being deducted? Why is it being deducted? And any portion that's not being deducted for damages or unpaid rent has to be returned to the tenant within those same 21 days. Next slide, please. Moving on to another topic, we're talking about the landlord's right to go into the property during a tenancy, landlord's right to access. This trips a lot of people up. I think, tenants and landlords don't have a great understanding of either way about when the landlord's allowed to come in and when they're not, what needs to happen. So it's good to know the law, before you get started to avoid trouble. So the landlord has a right to go into the property for certain purposes, to inspect the property from time to time, to make repairs or improvements, as are necessary, to supply services. So if there's an issue with the electric or the water or the gas, to make those, to get those services working, or to show the unit to prospective renters or purchasers. So those are all appropriate reasons why the landlord might need to get into the unit. Except in cases of emergency, though, the landlord has to let the tenant know 48 hours ahead of time in writing that they intend to come in, so the tenant isn't taken by surprise. And the landlord also can only enter at reasonable times. Generally, we think a reasonable time is about 8 a.m. to 8 p.m., somewhere during the daytime. If the landlord's trying to come in the middle of the night, that's likely not going to be reasonable. And the landlord, can't use the right of access in an unreasonable way to harass the tenant. So that could be coming in at times they know are bad for the tenant. That could become, giving the tenant notices that they need to come in and inspect every week or something like that, so often that it would be harassing. Both parties have to act reasonably. The tenant has to let the landlord in when there's an appropriate purpose, and the landlord has to make sure that when they're going in for an appropriate purpose, they're not doing it more often than they need to, and they're providing appropriate notice. So if the tenant doesn't allow the landlord in, the tenant can get a court order, seek damages, or terminate the lease. And if the landlord goes in without providing the right notice, or is harassing in their use of the right to access, the tenant can go to court and get damages as well, and plus attorney's fees. So it could get very expensive. Next slide. Repairs. Phil has talked a little bit about inspections and so when things are wrong with the property, what happens? Well, the city does inspect and will sometimes cite properties. And it's the landlord's obligation to keep those properties in compliance with the codes. If the landlord can't turn that responsibility over to the tenant. They can't say, well, you're the one living there, so you got to fix it up. Unless the parties make a separate agreement to that effect. And if they're going to make a separate agreement, say that the tenant's responsible for making certain repairs, that has to be in writing, and the tenant has to get something for that. There has to be appropriate compensation, whether that be that they're being paid for it, or they're getting a rent credit, or whatever it may be. And so the landlord also has an obligation to address criminal activity on the premises, so that other tenants aren't endangered by that. And that can mean evicting tenants that are participating in criminal activity. It doesn't have to. If it's something that they can just tell the tenant to stop and it's minor, that might be sufficient. But the landlord does need to deal with it. Next slide, please. So kind of continuing on the topic of repairs, what happens if the landlord doesn't make the repair? Well, then the tenant may give the landlord a written notice that there's something wrong. So, how much notice is required depends on what the tenant wants to do. If the tenant says, well, there's so many things broken, I just want to move out, I want to break the lease. They have to give the landlord 30 days notice ahead of time in writing. And then if the landlord doesn't make that repair within those 30 days, then the lease is terminated and the tenant can move out. If the tenant wants to make the repair themselves, they would give the landlord 14 days notice. So they'd write a letter, say, you've got, here's the issue. If you don't fix it within 14 days, I'm going to fix it myself. And if the landlord doesn't make the repair, then the tenant can find, an appropriate tradesman to go in, make the repair, and they would pay and get a paid invoice and submit that to the landlord and deduct the cost of the repairs from the rent. They can, if the tenant's going to do what we're calling repair and deduct, they can deduct up to $200 or half the rent, whichever's greater. So that's kind of the high end of what they could do. Purpose of that is you don't want tenants to be in charge of making really expensive repairs to the building. If the city has cited the landlord for a defective condition that still hasn't been repaired, the tenant can give 14 days notice, and then they can withhold an appropriate amount of rent reflecting the reduced value of the property without making the repair. So they don't have to fix it. They can just say, it's not worth the rent you're charging me. I'm going to pay you this reduced amount instead. And then finally, if the conditions issue is a failure to supply essential services, so if there's an issue with the water, issue with the electric or the gas, tenants only need to give 7 days notice in those cases before they would be able to employ remedies under the ordinance. Next, please. So, we're talking about repairs. One issue that often comes up with repairs, landlords don't like it when tenants call the city, understandably. Landlords don't like it when tenants are complaining a lot about conditions of the properties. And we sometimes see landlords take action against tenants by, raising their rent or threatening to evict them, refusing to renew leases because these tenants are being a pain in the rear end and complaining all the time. Unfortunately for those landlords, that's unlawful conduct. That's unlawful retaliation that is prohibited under the Evanston Ordinance as well as other laws. If those actions are taken within a year of the tenant making those complaints, then they're presumed to be retaliatory, and the tenant can go to court and get damages up to twice the rent and attorney's fees. So as annoying as certain tenants may be, it's a bad idea to retaliate against them by trying to raise their rent or decrease their services or take some other action to get them out of the property. Next, please. So what happens when the tenant doesn't satisfy their obligations under the lease? Well, the landlord has, their own notices that they'll give in those circumstances. If the tenant doesn't pay rent, they should give the tenant, the tenant doesn't pay rent, the landlord should give them a notice stating that, a written notice stating that if the rent isn't paid within 10 days, the tenancy will be terminated. We should note that this is more time than is required generally under the law in Illinois. So this is an Evanston specific thing. If you've been a landlord somewhere else in Illinois, this is going to be more time than you're used to giving. But if you don't give that time, then and bring them to court, your case is going to get dismissed. So you got to comply with the law. If the tenant breaches the lease in some other way, other than not paying the rent, the landlord can give them a notice stating that if the breach isn't remedied within 30 days, the tenancy will be terminated. And again, this is more time than is generally required under the state law. This is an Evanston specific thing, so it's important to know. tenant can't keep making the same mistake over and over again. So if they do fix the issue within the 30 days, but then it comes up again in a couple months, the landlord doesn't have to give them a chance to fix it the second time. They can just give them a 30-day notice and say, no, your tenancy is terminated. You need to move out. So they kind of have that one opportunity to, get to fix their issue or, comply with the lease. And then after that, they're presumed to know better. This isn't an Evanston specific thing, but the Evanston ordinance does call it out specifically, so I wanted to mention it. If the landlord accepts rent after they know about a breach of the lease, or if they allow a tenant to continue breaching the lease during their tenancy and know about it and don't do anything, then they're deemed to have waived their right to terminate based on that thing. If a landlord intends to terminate the lease because of a breach, they need to not accept further rent from the tenant, and they need to speak up if the tenant is doing something that's not consistent with the rental agreement. And then finally, this isn't an issue of breach, but if the landlord wants to terminate a month-to-month tenancy or not renew a lease, they do have to give the tenant notice of that as well. They need to give 30 days written notice before the end of the tenancy. And if they don't do that, then the tenant can stay for another 2 months after they finally do give notice. So it pays to be on top of these things and to give the notice that's required. Next, please. What happens if you give a tenant a notice that the tenancy is terminated and they don't move out? Some landlords, especially during the pandemic, were getting frustrated and kind of taking the law into their own hands and using what we call self-help remedies, trying to, get the tenant out by any means necessary. But it's important to know that that is not a lawful thing to do. You have to bring the eviction case and evict through the sheriff, even if it takes a long time. Landlords cannot take actions that interrupt the tenancy in order to get the tenant to move out. They can't change the locks, remove locks, plug locks. They can't block the doors, barricade the doors, remove doors and windows, remove personal property. These are all things that they sound extreme, but we do see them. We see this happen, with some regularity. The landlords also can't interfere with utility services. This is probably the one we see more than anything else, where landlords will turn off the electricity, cut the water or something, to try to get the tenant to move out. That is an unlawful interruption of the tenancy and can subject the landlord to fines. They can be fined up to between $200 and $500 a day by the city if they're found to be engaging in that conduct. They could also be arrested if they refuse to end the lockout. And then finally, the tenant can bring a lawsuit, as we've talked about for some other sections here, and get damages and attorney's fees for the lockout. So again, as frustrating as it may be sometimes, when you've got a tenant that just needs to get out, you got to go through the courts. Next, please. And then just to finish up, I know I've been talking a while and this is all pretty technical. Couple other laws that you should be aware of. Phil mentioned the fair housing ordinance in Evanston. There are also fair housing laws at the state and federal level. What those laws deal with generally is just, the landlords can't discriminate in providing housing or in the way they interact with tenants based on a number of different qualifications, race, religion, sex, all that. Important to note in Evanston, that includes sexual orientation, includes gender identity, it includes source of income, which means that you can't, refuse to rent to somebody because their income comes from a subsidy like Section 8. So, it's just important to remember that, these laws exist and more information about that can be found in other places. And a couple other things, I think we've moved away from the slide, but the Americans with Disabilities Act, deals a lot with, accommodations that you might need to provide to tenants based on their disabilities. Immigrant Tenant Protection Act, deals with tenants who are not citizens and how they need to be treated. They can't, landlords can't demand proof of citizenship. They can't threaten to report people to ICE or things like that to get them out. Safe Homes Act deals with, people who are victims of domestic violence. You can't evict somebody for being a victim of domestic violence, even, if otherwise they're, the police being called to the property might be a cause to evict. The Just Housing Ordinance deals with tenants who are returning, who might have been incarcerated or convicted or arrested or things like that, dealing with, when they can and can't be reasons not to rent to somebody. Rental Property Utility Services Act deals with situations involving utilities, when landlords can change from landlord provided to tenant provided utilities, and deals with situations where tenants are being charged to, for utilities to common areas or other units and things like that, which is certainly unlawful. And then last, the Eviction Act. If you do end up having to terminate a tenancy and evict a tenant, it pays to look, to make sure that you're doing it in compliance with the Eviction Act, because if you don't, you can pay a lot of money and go through a lot of trouble only to have your case dismissed and have to start over. So that's all I have. I know it was a lot to absorb, but as Phil said, if you send us your email address, if you put your email address in, we'll send you the PowerPoint so that you have that information to refer to. And then I think Taft is going to take over from here.
Thanks, John. All right.
And just so you know, you are able to turn on your cameras if you'd like.
Okay, yeah, and I did wash my face this morning, but I'll leave it as it is. Thanks, Anna. Good afternoon. Thanks, John and Phil. Gosh, you guys went through pretty much everything that a property manager needs to affect. And for those of you listening, these things, the things these two attorneys spoke about was, and I guess as a landlord, you've got to, all these are efficacy things that you actually have to do as a property manager. I spent, 30 years managing all kinds of stuff. When Anna read this introduction, I'm like, where did she get all that stuff, But I'm not going to go through this. This is going to be quick, so we can get to the Q&A. I put together this little list of things that I consider important, strong tools for success. And the most important one to me on the top is flawless property, thorough apartment preparation. When a new partner / tenant resident comes, if that place is absolutely flawless, that starts things off on the right foot. If it's not really well done and you got to go back and do maintenance things, again, it starts with, it leaves a bad impression in the tenant's mouth. I've managed high-end apartments in the, 70s, 80s, or a studio apartment was $2,000. It was very fulfilling to start working in affordable housing and to prepare a nice apartment for someone that didn't have much. And as we gave them their keys and they opened the door to their apartment, they were very tentative. It's like how they just did not expect that someone would prepare something so wonderful and nice and clean for them. That also starts it on the right foot. And one of the things about having a flawless entry, it's easier for the rent to flow. Very easy. And of course, thorough credit background investigation. I believe in a home visit is part of the processes I always put in place. If you're coming to my home, I want to see how you're living at your place. And then once you're with us, quarterly, we're going to come around and spend 5 minutes just to duck in, and no secret about what we're looking for. And of course, you get a notice in advance. Want to make sure that our maintenance guys are doing what they should do, and that you as a tenant are doing what you should do, and that a family member that might have an ankle bracelet is not camped out at the unit. And of course, that bottom of eviction, last resort. Let's see if we can't figure things out. Next slide. Additional things, all of these additional tools are things that helped me a lot as a property manager over time. Marketing, tenant selection, how to pick a good tenant, and of course, appealing the taxes of the property, fair housing. I testified before the county on this Just Housing Amendment about giving ex-offenders an opportunity. I won't go into how many times that I've done that, and it worked out. Nuisance abatement, keeping drugs and crime away from the property. And then conflict mediation is a really, really important one, because as time has gone on, the relationships, not only between landlords and tenants, unfortunately between all of us as a society, has gotten strained, and so I think a right attitude and a good listening attitude can help when it comes to resolving conflicts. one of the things I've learned is to be a good listener, you know, and not have an ego about I'm the boss, but the people that pay the freight, I think we should look at us as a service provider, and the people who pay the rent are the boss. And maintenance is very important. So, and as I said before, last resort is eviction. Next slide, please. All right, and this is probably my last slide, since we're going to just do 15 minutes here. To cultivate the right relationship, you start off with a flawless place to live, and explain to the tenant what's expected of them as a tenant or a partner, and also what they can expect from you as a manager, or landlord, or owner of the property. I spent several years being the 311 landlord hotline answerer for the City of Chicago's landlord hotline. And I can tell you, those several thousand calls a year I got, there's a lot of misinformation and lack of education. And so the class that I taught, I'd always invite them to come to the class. Oh, one other thing, I no longer work for Chicago Community Loan Fund. When the pandemic started, I decided I'm an old guy. I'm going to sit on my butt all the years I've been working. and our president said, give us one more year. I said, I'm not giving you another minute. I started working in 1962, not 82, 92, 1962. I joined the United States Army. Got 9 brothers, all of us served. And my older brother spent 10 years in the Pentagon with Colin Powell. He still walks like he's in the military. Spent 40 years. So grew up in Springfield and learned about service. And I think that's what helped make me a better manager. We had a thing called the official greeter, and we were really poor with 10 kids. And when you got to be an official greeter at our church, they bought you this new black outfit, and I stand at the door and say, welcome to Pleasant Grove. We're glad you're here. God bless you. So that attitude of service is what I took into the real estate industry, which was quite a learning experience. My background heretofore, as Anna said, I was a medic in the United States Army, but I spent several years doing autopsy training and medical research at a hospital in Springfield before coming to Chicago. So my background was biochemistry and biology, GD Searle, Continental Can, and those kind of places prior to getting into real estate. But those 30 years learned a lot about people and tried to give really good service. Took on 1,000 units from the Chicago Housing Authority in the 80s. Those few years were quite challenging. Ran a housing authority also in the city of Rockford, Illinois. So lots of years of working with and taking good care of people. We used to, when Evanston was working on their ordinance, Paul Bernstein, who a lot of people know is a famous lawyer, we used to meet in the Parasol Room there in Evanston, their economic development place. And he would talk to them about their ordinance and I would listen. But anyhow, that's about all that I have. Do I have another slide? I don't think so. Do I? No. Oh, I do. That, I wish I had the before slide. When, in my opinion, when you prepare a unit like that, there are no excuses you have to make. It looked so awful before. We even put a couple of sconces there and dug that little thing in the wall to give it a little interesting effect. I love radiators. And if you had seen those floors and how that looked prior to us really doing a good job, I was so excited I took the picture before we put up the blinds. But when you put a tenant in an apartment like that, you're starting on the right foot. And this happened to be, I had 11 buildings in this particular property in South Shore. 5 were project-based, Section 8, and 6 were what we call tax credits, mod rehab tax credit back in the days. And this was one of our project-based Section 8 units. So if you show a person with not a lot of money or with money, a unit like that, I think you're going to start off on the right foot. I think that's my last slide on it, and that's all I've got to say. All right.
Yes. So now it's time for questions. And we've had a few come in as the evening progressed. So we'll start with the first one. This question says, what happens if a tenant pays no rent, the landlord does not evict, and the lease ends? What can landlords do to remove a tenant once the lease has ended?
We got 2 attorneys. I'm sure they can answer.
So we're talking about a situation where the lease has ended, the tenant is behind on rent, and they won't move out. Is that what the question is?
Yes, so they have not paid rent and the landlord does not evict, but the lease ends, what can they do to remove the tenant at that point?
Well, they would still need to go through eviction court if the tenant won't move out, but they would have an option. Then they could give the tenant, one or both of a 10-day notice to pay the rent. Or they could give the tenant a 30-day notice to vacate. If the tenant is current up to the end of the lease, the danger of giving the 10-day notice is if the landlord takes more rent, they could be establishing a month-to-month tenancy now, and let the tenant stay farther. So they might be better served giving the 30-day notice saying the lease is over and you need to move out. But either way, that would be the thing that they would need to do, is give an appropriate notice and then take the tenant to court if they couldn't work it out. Like Phil said, a lot of things are best resolved with talking. So maybe just trying to figure out why the tenant hasn't moved out, why they're not, what their situation is. It might be more cost effective and get the tenant out sooner to try to work with them to resolve their situation. Because once you file an eviction case and that becomes a public record, it's going to make it more difficult for that tenant to move, because anyone they're going to want to rent from is going to see that they're in court and is going to is not going to want to do that. So I'd say first you might want to talk to the tenant, figure out what's going on, see if it's a problem that can be resolved. Some landlords, if they want the property back because they're going to sell it or something like that, or they're just losing money on it, will even pay tenants to move out because it's cheaper than paying $300 to file an eviction case and get them served, and maybe pay a lawyer to go to court, and then lose the 3 or 4 months of rent while that process is going on. So I think thinking practically is an important part of being an effective landlord and effective property manager. And sometimes the most practical thing is just whatever we need to do to get them to in a place where they can move. Phil, I don't know if you have anything to add to that.
No, I think that's great advice. And I think, I don't really have much to add to that. I think taking Taft's advice of, being a good listener and reaching out and listening to what it is, whether you're not going to be able to solve as, everyone's issues. You can't, make bills or whatever, things go away in someone else's life, but you can listen. And then what I would follow up is always offer a solution. If and I tell this same advice to tenants: if there's a problem, don't just complain about the problem, also offer or come up with the solution that you'd like to see. Because complaints just for the sake of complaints, or complaints without any direction, are much less helpful than bringing up an issue and also at least some suggestion for a possible solution. And I think if you have a tenant like that, and I'd encourage that landlord to reach out to me to discuss further offline, about how to approach that conversation and have that conversation with their tenant, because I've helped a lot of parties, resolve an issue like this without having to go through court, which is just, ugly for everybody, or at least a pain and costly and time consuming.
Okay, our next question is, what is the escalation process for landlords/homeowners who repeatedly get cited without consequence?
I'm not sorry,
sure.
go ahead, Phil.
I'm just asking for clarification because I'm not quite sure. Are we asking is the question, what is the escalation process for a tenant whose landlord has been cited for code violations?
If the attendee that asked this question could raise their hand, they could ask the question live, or if they could send a message through the chat, and we can get some clarification on that one. So again, the question was, what is the escalation process for landlords/homeowners who repeatedly get cited without consequence? Okay, so the attendee wants to ask the question live.
Can you hear me?
Yes.
Okay. Good evening, and thank you for your comments this evening. So the question may not be for this audience or presentation, but I was asking for landlords who move into a community and they have tenants and they don't keep their property up to standard. So I don't know who the speaker was, but in the beginning, you talked about standards and inspections, and these properties are inspected, but, and I understand they're fined and have to go to court, but there are no real consequences because the properties are still not maintained. And many of these persons are people who don't live in the community, but they're developers and others who just buy up property and then don't maintain it. Thank you.
Thank you for that clarification. That's very helpful. So yeah, I mean, if a landlord does not, or a building owner generally does not repair the building, you know, when they're cited, when they're issued citations, they can be taken to court. The court can order the repairs to be made. If the repairs still aren't made after the court has ordered it be done, you know, there's a process by which, you know, the liens could be placed against the property, and it could even be the landlord could lose ownership of the property if it's not repaired. It can be a time-consuming process for that to happen, but you know, that's something that I'm sure the city's law department would be able to speak more about.
And I would just add that I'd encourage anyone in one of those buildings. I certainly understand the frustration of someone that's not from the community, certainly owning a bunch of units and not keeping them up. And I can imagine that person's not going to be on a call like this that's geared to the majority of smaller landlords that are doing a much better job there. I'd encourage those folks to call MTO or another organization that can talk to them about organizing themselves, because if they are dealing with someone that is not local and it's a really big company, it's hard to get a hold of folks. One tenant is less likely to get a response than all the tenants if they try to communicate and organize themselves together. That's, in my experience, the only way I usually see large-scale success. And there's a lot of buildings in Chicago, at least, that I can point to that were really in bad shape and now are really amazing places to live. Even near our office in the South Loop, a building that used to just be crime-ridden and just decrepit, honestly, and now because of the Tenants Association, the landlord is also now doing their part, and they live in a place that they're proud of. So, you know, organizing is something I'd encourage folks there to look into.
Also, you know, for someone who's not a tenant in the building, but is maybe a neighbor or a community member, you know, contacting your alderman is a good place to start. You know, just put it on the radar of someone who's accountable to the, you know, to the voters, you know, that this is a problem and needs to be addressed, and that can sometimes move things along.
All right. So the next question is regarding the breach of contract and leased terms. The person asked, does giving the 10-day notice and then start legal proceedings the path to take, assuming the tenant does not leave?
I'm guessing this is maybe a follow-up to the first question that we dealt with. I think that's certainly one way that someone can go when the tenant's behind on rent. As I mentioned, if the lease is expired and the landlord's accepting rent for periods after the expiration of the lease, that can establish a new tenancy. So if the landlord isn't just concerned about the money and wants the tenant, does not want to continue the lease for other reasons, that may not be the way they would want to go. They might want to give a 30-day notice to vacate because the lease had ended. But that's something that they could do if they couldn't work the situation out with the tenant.
Okay, thank you. So next question asks, are there benefits available for landlords whose tenant is an elderly parent who does not and cannot pay the rental rate? Senior housing facilities receive tax exemptions and benefits that relatives trying to make sure their elderly relatives can age in place do not receive.
Well, I guess, start addressing this. I mean, if the elderly parent is not paying rent and has not paid rent, then they would not be considered a tenant. So, I don't know that this is really a landlord-tenant question, but if you are a caretaker for an aging parent, if they're living with you and you're helping them with their care and necessities and things like that, there is you can get compensation through Medicare for being a caretaker like that. I don't know the details of that, but that might be something to investigate.
Thank you. Next question asks, for security deposit statements, is the 21-day time frame when the tenant needs to receive the notice or when it's mailed?
That's a good question, and I don't have the text of the ordinance in front of me. So I would encourage you to look to the text. That would be section 5-3-5 of the ordinance. You can look at exactly what it says. We had a link in the PowerPoint, or in the PowerPoint, so you could just follow that. I think it has to be sent within 21 days. It's harder to determine when a tenant would receive something, but check me on that because I don't have the language in front of me.
And again, if you wish to receive the links, please leave us your email once you close out of the webinar.
And I don't know who asked that question, but in the meantime, I went ahead and fact checked Jonathan as requested. Looking at the text, and it is delivered. So it has to be in hand. So the text says all itemized, the list by the landlord and a written notice delivered to the tenant together with the amount due 21 days after. So it needs to be delivered. So I'd encourage, what I encourage tenants and landlords, if they're sending something, send it, with proof of delivery. Also, email it and text a copy as well. If you text or email with someone frequently and you think they'll respond, that's a good way to also get proof of delivery. So cover your bases by sending it all possible means that you can.
Okay. The next question asks, as a landlord, am I under any obligation to renew the lease? I'm not talking about being retaliatory. Sometimes circumstances change and I might prefer to have someone else in the unit.
Generally, the answer is no. There's no obligation to renew the lease. If there are other reasons that you just want to rent to someone else, or maybe you want to take the unit off the market or put a family member in or something like that, there are plenty of legitimate reasons why a landlord may not want to renew the lease. So no, there's not a general obligation to do that. You just want to make sure that the reason that you're doing it is not retaliatory or, would be a fair housing violation. For example, if somebody decides not to renew a lease because their tenant has kids or something like that. Now that's would be potentially discrimination based on, their family makeup at that point. So, you just want to think about why it is that you want to rent somebody else, and see if that might trigger any of those types of laws that I was talking about, retaliation, or, some of those at the end relating to discrimination or other protected statuses.
Okay, thank you. The next question asks, what is the current interest rate on rental deposit funds that are turned over to tenants at the end of each lease year? Is this higher than the interest rates we can get in our separate deposits account?
Again, I don't have it in front of me right this minute. I think the rate is 0.01%, so it's very low. So, you know, I think it's probably comparable to the interest that you're getting in the savings account. But we did include a link to the website that the City of Chicago updates every year with the interest rates, and you can see, I think, the past, you know, 15 or 20 years on there, what the rates were. So you can get a sense of how they might fluctuate.
Yeah, it is 0.01.
Right, that's correct.
And it does seem silly. You know, sometimes, you know, I have to go through all this trouble to pay somebody, you know, 4 cents or whatever it is. But again, you know, the first slide that Jonathan had up, the caution, don't get tripped up, that it's a good reminder of these types of things. You know, you don't want to trip yourself up and have much, you know, bigger headaches on your hand because you forgot to give someone, you know, the 3 cents that they're owed in interest. So it is astonishingly little, but it makes it easy to comply with. You just got to go deliver it and make sure you document that you've done so.
Yeah, it's a great point that Phil makes. There are attorneys that make their entire practice on suing landlords over these little security deposit issues because, you know, they can get their fees paid, you know, as part of that case. So, you know, they can take them for free and make the landlord pay them. It's so it's much better to just pay the 4 cents.
Okay. The next question says, problem tenants are not just problems for the landlords. They are problems for the other tenants in the building too. Do you have any recommendations on how to handle this with other tenants when one tenant is behaving poorly?
Yeah, this is staff. I don't, if you like, if I can, I'd like to take that one. I've dealt with it often on the hotline. And as a manager, one of the things that I used to do is we'd have a expectations discussion for all new tenants. And one of the things I promised them is that if there's a problem in the property and you don't see me, I am probably dead. That's how seriously I take my commitment. And my expectation of them is similar. If someone is a problem, if I walk by their door and the walls are rocking because of their stereo, I will knock on their door at that time and say, do me a favor, play it just for you. And when I rent it to you, I do recall telling you that everybody has a stereo. So be considerate. If that continues, then they get a face-to-face meeting. And if it continues again, then they get a 10-day notice. That's a violation of the lease. Everyone's entitled to what's called quiet enjoyment, you know, and so I say to the other people who are complaining that as a manager, I can certainly file an action with our favorite attorney. And if we get to court, what I'd like you to do is be supportive of this. So the judge is not I'm just saying it because I don't like this tenant, because certainly tenants are going to get representation and 4 or 5 people can say, I live next door to him and my life is hell. So that's how I've handled those cases. But again, on the front end, when we tell people our expectations, generally you'll get a better outcome.
Okay, so that is the bulk of our questions. Does anyone else have any other questions? Or if you would like to ask live, you can raise your hand. No takers? All right. Well, I just want to thank Phil, John, and Mr. Taft for joining us tonight, and all of the landlords that made some time today to attend the webinar. Again, once you close out of the meeting, you will receive a pop-up window where you will be able to put in your email so you can receive all of the links. So thank you very much to everyone for coming.
Thank you, Anna. John, Phil, good to see you guys.
You
Thank
too.
you.
Thank you as always. I really appreciate it, everyone. Thanks.
Yes,
Yeah,
sir.
thanks Taft and Phil. This was appreciate everybody's participation.
Good job, Anna. Ask for a raise.
Thank you. Have a great
welcome.
night.
You too.
You too.